Hello everyone and welcome back to Basic Law Knowledge. Today we will review section 14 to 18 of the Nari Shishu Nirjatan Daman Ain 2000. Section 14. Provision on revealing the identity of women and children who are victims of torture in the media. Subsection 1. If a woman or child is a victim of any offense under this law, then no newspaper, media outlet, online platform or social media is allowed to publish or broadcast any news, information, name, address, photo or any other details in a way that could reveal the identity of that woman or child. Subsection 2 says, if anyone breaks the rule mentioned in subsection 1, this means if someone publishes or shares information that reveals the identity of an abused woman or child, then that person can be punished up to 2 years in jail or a fine up to 1 lakh taka or both jail and fine. Section 15. Recovery of fine from future property. If someone is fined by the tribunal for crimes mentioned in section 4 to 14 of this law, the tribunal may decide that the fine should be treated as compensation for the victim. If the convicted person cannot pay the fine or the compensation because they do not currently have enough money or property, then the amount can be collected from any property they may own or gain in the future. In such case, the fine or compensation will take priority over any other claims on that property. Section 16. Procedure for collection of fines or compensation. If the court fines someone under this law, it can tell the district collector to make a list of the person's things like land or things that can be moved. Then by following the rules or the court's decision, the collector can sell these things in an auction or sell them directly without auction. The money from the sales goes to the court, which will give to the person who got hurt because of the crime. Section 17. Punishment for filing false cases or complaint. Subsection 1. If a person files a false case or complaint against someone else without a good or legal reason, with the intention to harm or damage that person's reputation or cause them loss, then the person who files the false case and anyone who helped him to file that case, they can be punished. The punishment can up to 7 years in prison and also a fine. This means making a false complaint on purpose to harm someone is a serious crime and can lead to jail or money penalty. Subsection 2. The tribunal set up under this law can take action and hold a trial based on a written complaint or even by itself if it thinks a crime described in subsection 1 has happened. This means the tribunal does not need a complaint every time. It can also start a case on its own if it finds a crime under this law. Subsection 3. After a case is finished under this law, if the tribunal finds that the complaint or case against a person was false and made to harass them, the tribunal can give the person who filed the false case a chance to explain. Then the tribunal can order that person to pay proper compensation to the person who was wrongly accused if he can't explain. If needed, the tribunal can also punish the person who filed the false case with up to 2 years and in prison. This means that if someone files a false and harmful complaint, they can have to pay money to the victim and may also go to the jail. Section 18. Investigation of offense. Subsection 1. No matter what other rules say in the Criminal Procedure Code or CPC, investigation of a crime under this law must be finished within 15 working days from the date when a person is caught red-handed by the police or caught by someone else and handed over the police. This means if the police catch someone committing a crime, they have to finish investigation the case within 15 working days after the person is caught. B. If the accused person was not caught red-handed, the police or officer must finish the investigation within 30 working days starting from the date they first get the initial information about the crime, or when an order for investigation is received from the proper authority or the tribunal. This means that if the accused was not caught right at the crime scene, the investigation must be completed within 30 working days after the police get information or an official order to start investigating. Subsection 2. If for a valid reason the investigation cannot be finished within 15 working days mentioned in subsection 1, then the investigating officer must submit a written report with the case diary and reason for the delay to the tribunal or magistrate before the investigation time ends. If the tribunal or magistrate is satisfied with the reason, they can allow the officer another 15 working days to complete the investigation. Here is a special note. If DNA testing is needed for the investigation and the tribunal or magistrate approves it, then the time for completing the investigation can be extended further, but only for the minimum time necessary to complete the DNA test. Subsection 3 says, after the investigation report is submitted, if someone files an objection against it, the tribunal can appoint a new investigating officer to carry out a further investigation. The new investigation must be completed within 15 working days after the order to investigate is given. Subsection 6 says, if the investigation is not completed within the time limit mentioned in subsection 1 or the extended time in subsection 2 and 3, then a report explaining the delay will be reviewed. If the tribunal or magistrate decides that the delay was caused by the negligence or misconduct of the investigating officer, or in some cases a government official, then this negligence or misconduct will be recorded in the person's annual confidential report, and if necessary, action will be taken against them according to the job rules. Subsection 7. After the investigation report is submitted, if the tribunal reviews the information and feels that a person named as an accused in the report should actually be called as a witness for the sake of justice, then the tribunal can order that the person be treated as a witness instead of an accused. Subsection 8. After the trial's evidence is finished, if the tribunal believes that the investigating officer or their senior officer has helped someone avoid punishment or neglected their duty by not collecting or considering important evidence, or wrongly made someone a witness instead of an accused without proper reason, or failed to examine an important witness, then the tribunal can consider this behavior as misconduct. The tribunal can then order the officer's higher authority to take proper legal action against that officer. Subsection 9. The tribunal, or if needed, the magistrate can order the authority in charge to replace an investigating officer with another officer based on an application or any other information. Subsection 10. While investigating a case under Section 9, the investigating officer cannot be transferred or replaced through an administrative order. Thank you so much for listening. Take care. Bye-bye.